Okay. Good morning, everyone. We are here with Hap May's legal play. Hap May himself is not here. I am Chelsea Alazi, and I'm here with Annalee May of No Relation.
No relation.
Annalee, tell us a little bit about what you do here at the firm.
Well, I am working in the probate area and in the wills, estates, and trust area. So I like to think of it as helping you with your affairs now while you're living and can direct who you want to care for you while you're alive, and also to help you direct what you want done after you pass so that your family members have a clear picture about how you want your affairs handled.
Right. And so you're here as today's expert on matters of probate. And today we are talking about wills, power of attorney, directive to physician, and all of the things that kind of go into that package of your wishes if, once you pass or are incapacitated and can no longer, I guess, speak for yourself. So I've got a couple of questions to kind of guide us that I have been asked along the way
Okay.
in my law school journey as an attorney. I think wills are one of those kind of, I like to call it the bread and butter of attorneys that it's just kind of something that we can do for you. We know a lot about. So what I get asked a lot, Annalie, is why do I need a will?
Well, there are many reasons you need a will, but the most important reason to me is that if you have a will, you can let your family know what it is that you want, what your wishes are. Um, a will can contain everything from specific items that you may want to leave a grandchild or child, and it can set up a trust for a minor child. And if you don't have a will, the consequences are just more problematic for your family. If you have a will, then you can go through probate. You can get what is called letters testamentary, which allows you to then go forward and change title to a home, sell a home, change title to a car, sell a car, anything of that nature uh, that you wouldn't be able to do easily otherwise.
Okay, so let's talk about that too, because I do have some people say, well, I have, retirement accounts or I have life insurance accounts and I've got a named beneficiary. Doesn't that just kick in automatically once I pass?
Yes, it does, but that is outside of probate. There are certain assets in financial institutions where you can designate a beneficiary, but not all assets are like that. For example, your home. If there are ways that you can transfer the title to your home upon death, but if that is not done, if there's anything out there that pops up, such as an oil and gas royalty or uh, a ranch or something real property, you have to change the title. And the only way you're able to do this, if you haven't prepared beforehand, is through a will.
Okay, so let's say I'm married and in Texas, it's a community property state. And me and my spouse are living in the house. If I pass, doesn't it just automatically go to my spouse? Does the spouse automatically take title in that case?
No, the spouse is allowed to live there and he has his one half community property interest. But in order to change the title, you have to probate the will.
Okay. Is it enough that I just maybe handwrite? I leave it all to my spouse, signed, Chelsea Alazi and dated.
Well, yes and no.
Stick it in my bedroom drawer.
Yes and no. Yes, you can do that. And you can make it very difficult for your family and children to then try and probate that will, because not that it can't be done, but it is very difficult. You have to prove up the signature. So you have to find uh, friends or bankers or somebody that knows you very well, knows your signature, is willing to speak on your behalf in a courtroom setting, and it just becomes more difficult. And in Texas, you have to have what is called a self-proving affidavit to attach to the will, which self-proves the will.
Mhm.
But if you don't have that, which you wouldn't if you just hand wrote it like that, then we have to prove up the will. And it's just a little more cumbersome, more expensive for your family.
Right. All of this would be burdensome on the family, basically. Um, okay, let's see. So the next question, right, the next question is, so along the line, so I like to call it the premium package. So you can get a will and just a will and maybe the self-proofing affidavit. Or you can get the premium package, which comes with and this is not an official title. This is literally just what I call it with family and friends that ask me, is that not only if you come in and get a will, but we're gonna suggest that maybe you consider getting a power of attorney, a directive to physician, and a HIPAA release and all of those, so that you kind of have like the full package should X, Y, and Z happen. So once you've got your will, next thing we discuss is whether or not you want to and should get a power of attorney. So can you tell us about powers of attorney?
Yes, and actually I like to flip that order. I think it's most important to get your powers of attorney in place first,
Okay.
because that's what happens if you're incapacitated while you're alive.
Okay.
And you don't want to leave decisions up to your family and friends that are too difficult for you to make, such as in a directive to physicians. This is when you tell your doctor exactly what you want. Say you're in a car accident and you have 6 months to live. How do you want to be cared for? Do you want heroic measures? Do you want a ventilator? Do you want a feeding tube? Or do you want palliative care where you're just made comfortable and have your best life for a shorter period of time? That's up to you, but that's something that we can address in a directive to physician. The other powers are the medical power of attorney, which often, mostly it's your spouse first. And then, but if you and your spouse are in a car wreck, who's next? Who comes in to speak for both of you? So then you can direct, do you want it to be a child? Do you want it to be all of your children that have to decide jointly? How do you want to handle that? And that's someone who will literally make medical decisions on your behalf. Then we have what is called the HIPAA release, which I like to refer to as more informative. It allows all of your family, your children, whoever you designate, your best girlfriend, to be able to ask the doctor questions, to communicate with the medical staff, to understand what is going on. You may not have power to make decisions, but at least you can understand and maybe help explain.
Right. The HIPAA release is kind of a big thing because a lot of hospitals and doctors are kind of tied with releasing even just basic information about what's happening, what care they're giving.
That's correct. And if you don't have the HIPAA release, you don't get the information. The other power of attorney is what we call a durable power of attorney, and it's financially related. And it's where if you're in a position where you're no longer able to take care of your finances, you can appoint someone to come in and step in and take care of that. And there are all kinds of powers in the financial power of attorney. You can allow someone to sell real estate. You can allow someone to write checks for you. You can allow someone to do anything and everything. And it's important to understand for this document, you have a choice to make. You can either, is upon execution of the document, the other person has the right to step into your stead and write checks or help, or it can be based on your capacity. So that's a very individual decision. I personally like to see it done immediately so that you don't have the person that you designated doesn't have to jump through hoops when it comes that time to step in.
And I just had a question. When you're incapacitated, do you then have to prove incapacity? Is that like a legal definition that you have to get a court order saying, okay, this person is truly incapacitated, now this power of attorney kicks in?
I don't know that you have to get a court order, but you do have to get a letter from the physician.
Okay.
So that is the hoop I'm talking about. If you are in a car wreck, for example, in the rent stew, and you have a child designated as power of attorney, it would sure be nice if that child could come in immediately and write checks to cover the rent or get money to help day to day, whatever is needed, other than having to then go to a doctor and get a letter. And then I'm not 100% sure about if it has to be sanctioned by a court.
Okay. I don't
Have to look into that.
Yeah, yeah. And I've also been asked, okay, well, let's say I just want my spouse to make all the decisions. I want my spouse to have this in Texas or just in general. Does the spouse need to have power of attorney to do these things?
I don't believe that a spouse needs a power of attorney. And it really, yes, we always put spouse first on a power of attorney because
If that's what you want.
if that's what you want, and some people don't, and that's okay. But it comes into play more if you and your spouse are together. Say you're in a plane crash, or you're in a car wreck, or you both get terrible food poisoning. Think of anything that could happen to you while you're with your spouse. Then who's next? Who steps in?
Right. And one of the circumstances that we discussed yesterday when we were talking about the subject was, well, what if you have, a second or third wife and you've got an adult child? In that case, there might be some conflict between who should be making these choices, who should be, moving things around, or like you said, telling a doctor what to do. So getting this stuff ahead of time lets you make the decision over who you trust with these decisions and who should be in line with having the authority to act on your behalf.
So what I think you're referring to is if, say, the mother or father of your children is not your current spouse.
Correct.
And that person comes in thinking that he or she has rights. Well, you want to make it clear and spelled out that no, I want this person to handle my affairs. And it may be the mother or father of your child, but you need to set it out clearly so the doctors know.
Right, right. And as far as financials go, I think writing checks is one thing, but being able to access accounts, I've had a couple clients come in version of power of attorney so that people at like Fidelity or Quest, like retirement accounts, will talk to me about things. But that's having the benefit of the client being here, being able to talk on the phone, being able to sign off on documents and saying, I want this person to be able to ask questions and do things on my behalf. I think a durable power of attorney and other documents like that, you could just send it in electronically, email, things like that, so that whoever's on the other side knows, okay, I can deal with this person.
And that is the hope. And 99% of the time, that is what happens. But your power of attorney is only as good as the financial institution on the other side is going to accept it. So there are rare occasions where we do have difficulty. And in that situation, it's something else that we include in our package is a designation of guardian. So if a financial institution refuses to honor the power of attorney, which does not happen very often, but if it does, we have another tool, and that is to go to the court and say, I need to be the guardian. I've been designated as the guardian. And then you get that designation, and there's no question with the financial institution. The court will order them to then deal with you or release funds, etc.
Okay, this is what I'm calling the premium package, because you get the will, the power of attorney, the what did you call
Designation
of guardian, directive to physician,
the HIPAA release. Yes.
Yeah, all in one go.
Yes.
So you're not kind of having to do it piecemeal. You've got all of the events, the what ifs taken care of.
That is the goal.
And I think another question before we leave is, okay, what if I trust this person over here with these things, but I don't want them to access my financials, or I don't want them to sell the house or cut checks for me. I'm okay with certain things, but not these others. Can you limit that?
Absolutely. There's a limitation of powers. There's a laundry list of things that they can do, and we check off what you want them to do or not. Most people want to grant all powers, but there are certain instances where you don't, and you can definitely do that.
Okay. Well, that's good to know. I guess kind of before we wrap up, I want to maybe leave a couple of strands to follow up on in future podcasts. Another reason people, might want a will, they ask, why do I need a will? Here we've been talking about family, we've been talking about real property, and that tends to get taken care of, I think, in intestate. If you don't have a will, it's intestate. These things eventually get ironed out. It might take some effort and work.
Well, that is a whole another podcast because intestate succession in Texas is interesting. It doesn't necessarily follow just like you think it will.
Okay.
You've got brothers and sisters, you've got parents, and all of that is taken into account. So it doesn't go straight to your children like you think it would.
Okay, so that's another thing, but I also want to mention pets, because one thing we've been seeing a lot of recently is, well, maybe I don't have children, or my children are taken care of with my retirement accounts, but I can't leave a pet as a beneficiary in my retirement account. So what
Correct.
happens to your pets when you pass?
And that's another area we can discuss.
Yes.
Set up pet trusts and work out a way that the pets are taken care of as well.
Right. And so more to come with Annalee May in later episodes. Thank you, Annalee, for being here.
This is right.
All right. And this was Chelsea Elazi and
Annalee May
with Hap May's Legal Play.